Good afternoon, everyone. I've got with me the Psychoactive Substances Act 2013. It's our simplistic solution to a complex problem. I thought what I would do is cover off the outline of how the Act works. The Act obviously has much broader application than just to synthetic cannabis, but as it happens, that's where the interest has been. And from there, I think I'd then move on to answer the question which no doubt all of you, as every person who knows about the Act asks me, which is, can we use it for cannabis? So to cover off how the Act works, the most important thing to understand about it is the purpose and principles, because they really explain, I've just thrown it on the ground, they really explain what the Act is supposed to achieve and how it works in practice. And the purpose of the Act is to regulate the availability of psychoactive substances in New Zealand to protect the health of and minimise harm to individuals who use those products. And the principles of the Act, that is the guiding principles which officials and decision makers have to take into account under the legislation, are that a psychoactive product that is approved for use by individuals should pose no more than a low risk of harm to individuals who use it. Before a psychoactive product can be approved for use by individuals, the degree of harm posed by the product should be assessed by the authority on the basis of the advice of an expert advisory committee and, gasp, evidence, including the results of preclinical and clinical trials. A psychoactive product that poses no more than a low risk of harm to individuals should be approved, and a product that poses more than a low risk of harm should be prohibited. And a psychoactive product that has not been approved by the authority should be prohibited on a precautionary basis until the authority has assessed it. So what that means in practice is that if you wish to bring a new psychoactive product to market, you first must satisfy the authority that it poses no more than a low risk of harm. Now that's not a particularly elegant way of phrasing it, but it's important because one of the things the Act is very clear about is that the products that are approved under it are not safe. They pose no more than a low risk of harm, but they do pose a risk of harm. In fact, the Act goes further. It is actually an offence under the Act to imply in your marketing of a product that it is safe. So the position is realistic. It reflects the realities of the use of psychoactive substances, which is they cannot be without risk. And it is broad-ranging. It covers a very, very wide range of substances. The definition of a psychoactive substance in the Act is very important, and it's relevant to the second part of what I'm going to talk about. A psychoactive substance is any substance that induces a psychoactive effect by any means in a person who uses it. But it does not include tobacco, alcohol, medicines, that's important, we'll come back to it later, herbal remedies, dietary supplements, or controlled drugs. So what that means, to give a short answer to the question, can the Psychoactive Substances Act be used for cannabis, is not yet. It does not apply to cannabis or cannabis derivatives. They are not eligible for approval under the Act. But I'll come back to that because that is something that could change in the future. So once a product is approved, or to receive approval, I should say, a product must satisfy the authority that it's safe. Having done that, there are a range of controls then placed on how it can be sold. The first is that it can only be sold from a premise that has a license to do so. It cannot be advertised in any way. The packaging must contain safety information, must not be attractive to children, must not communicate the product is safe. Steve, most of these ideas will be very, very familiar to you. The product must have all of its adverse reported effects reported immediately to the authority, and it is subject to removal from the market by the authority if the authority determines that it poses greater than a low risk of harm. There are licenses controlling every stage of the manufacture and marketing of an approved psychoactive product. You require a license to manufacture, a license to import, a license to wholesale, a license to retail, and a license to research. So the control placed over these substances, and principally this includes synthetic cannabis at this stage, is extensive, and it extends to virtually every stage in the chain of supply. At the moment, there are no substances that have received formal approval under the Act. The Act creates, however, an interim regime where substances that were on the market for the 3 months preceding, or products I should say, that were on the market for the 3 months preceding the enactment of the Act may remain on the market provided they can satisfy the authority they were in fact on sale for the 3 months preceding the enactment of the legislation, and that they pose no more than a low risk of harm. At the moment, the authority doesn't have any reliable safety data, so what it's relying on is reported adverse effects through the Poison Centre and through the clinical reporting system. I'm conscious that a member of the committee is in the room, so I won't go into too much depth about that at this stage because I'm currently doing an appeal in front of her, so it'll be good. So where does this get us in terms of cannabis? Which is, let's be frank here, the question it's on everyone's lips. As I said, the starting point is that because cannabis and tetrahydrocannabinol are controlled drugs, they are not at this stage eligible for approval. But what if they were? What would happen if tomorrow we abandoned the international drug control system and amended the Misuse of Drugs Act to remove cannabis and tetrahydrocannabinol from the Misuse of Drugs Act, so they cease to be controlled drugs? How would cannabis then fit in with the Psychoactive Substances Act? As it happens, there's actually a second hurdle you'd have to get over. And it's one that, again, Steve accurately pointed out earlier this morning, which is that one of the other things that a psychoactive substance can't be is a medicine. And it turns out that if you look in the Medicines Act, you'll actually find that tetrahydrocannabinol and cannabidiol are both prescription medicines. And the reason for that, of course, is that they are both the active ingredients in Sativex. So that would be another issue that you would have to work through. But having got through those, how would cannabis work under the Psychoactive Substances Act? The first thing to bear in mind is that the Act approves products and not substances. And what I mean by that is that you could never get cannabis approved under the Psychoactive Substances Act. The Act just doesn't work that way. What you would have to do is come up with a cannabis product, say a pre-rolled joint or a pill or a drink or, I don't know, a cookie or something, and you would take that then to the authority and seek approval for it. And what that means, of course, is that having got that approval, no one else could then turn up with another cannabis product and say, well, I want approval too. The Act is clear about that point because frankly, it's frankly for a very simple reason, it is a commercial reason. One of the issues that was identified quite early on when the Act was being prepared was the problem of free riding, which is to say that the first individual puts forward the money, does the work, proves their product is low risk, and then somebody else who already knows what's in it, and will know what's in it because the label has to say so, produces exactly the same product and takes it to the authority and says, I'd like approval too. Obviously, no one's going to want to be the first person across the line because they're going to bear all the risk and spend all the money, and everyone else is going to reap the benefit. So what the Act does is say that you can't reuse that safety data, that each individual person has to put forward their own data that they've come up for and have effectively paid for themselves. So there would presumably, over time, come to be a range of approved products under the Act, a range of approved cannabis-based products. So each individual pre-rolled joint or pill or drink or cookie or what have you would have to be approved and assessed by the authority separately. One of the other things that I think is interesting about the Psychoactive Substances Act as regards cannabinoids is the issue of combustion. This is something that has been repeatedly discussed and raised as a possible issue in terms of establishing whether a product poses more or less than a low risk of harm. And the reason for that, of course, is that setting aside the psychoactive effects of a particular substance, and for that matter its toxicity, its means of administration is going to play a significant part in assessing its risk profile. So what that might well mean is that it's very difficult to get smokable cannabis over the line, whereas a pill or something that you vaporize or that you drink, that might be more appealing. So there are options under the Psychoactive Substances Act for approving cannabis in the long run, assuming you can get past our government's fundamental position at this stage that cannabis is a controlled drug and must stay that way forever and ever, amen. Interestingly, the former Associate Health Minister, who in some senses was the architect of this legislation, as he described himself, said in a blog he published recently that perhaps it was time to rethink that, and perhaps we should just shove all of our controlled drugs through the Psychoactive Substances Act and see where they wind up. Now that is a position that has a certain appeal to it, because it means you could develop over time a single consistent regime for regulating all of our psychoactive products. Whereas at the moment, you've got psychoactive substances, which go through the Psychoactive Substances Act. You've got controlled drugs, which are nothing of the sort, but we pretend are illegal. You've got herbal remedies, you've got dietary supplements, you've got alcohol and tobacco, neither of which would ever be approved for sale in a modern regulatory regime, but which we are now stuck with. And all of them have slightly different regulatory regimes. All of them have slightly different controls. And it would make sense in the long run to try and bring those together. And I think that's probably where the future lies, is trying to bring together all of our, treating these substances not as though there are drugs and there are psychoactive substances and there's tobacco and alcohol off to the side of it and then there are medicines, but trying to fit them all in under a single act along the lines of the Psychoactive Substances Act. Now, I don't think the Psychoactive Substances Act is that piece of legislation. It has a long way to go. It's a good first step. It's a good first step because it's the first time that any effective, I think any New Zealand government, and more or less any government worldwide, has accepted that perhaps it is okay that some people use drugs. And more to the point, if they use drugs, it is better they do so in a way that is controlled, in a way that is regulated. Interestingly, not in a way that is taxed, and I think that is a gap in the Psychoactive Substances Act. There's no real mechanism under the Act for controlling the price of products. The Act allows for a levy to be imposed on licence holders, but the levy can only be used to fund the authorities' operations and not to recover harm. Now, I think that's a gap. I think that a good model going forward would be similar to the one used for handling problems caused by gambling harm. In New Zealand, what we effectively do is tot up all the cost of our gambling harm and then make our gambling operators pay for it. It might well be that that's an option under the Psychoactive Substances Act in the future. It will be reviewed in 5 years, so some of these options remain open for discussion. The other thing that's important to bear in mind about the Act and how it works in dealing with synthetic cannabis, and in fact any other products, is that it is still very much a work in progress. Much of the detail of the Act remains to be filled in by regulations. Those regulations were supposed to be made by the end of next month, then it became January, then March, and I gather it's now April. And those regulations will be key because they will fill in the details, and most importantly, they will set the threshold for approval. And this is the big unanswered question about the Psychoactive Substances Act, more than anything else. What does low risk of harm actually mean? Because if it's too low, and if the threshold is too low and nothing can get approved, there's no point. And if it's too high and everything gets approved, then it's failing to achieve its purpose. So the balance must be found somewhere in the middle. And my sort of controversial statement for the afternoon, I suppose, is there does seem to be a bit of a strange attractor among people who talk about the Act, who assume that that threshold line must be about where cannabis is. And I think that's based primarily, more than anything else, on wishful thinking. Because there's no, for a start, you couldn't set the threshold where cannabis is, because every cannabis product is different, and every cannabis product would pose a different risk of harm. The Act isn't designed as some sort of backdoor way of rubbing it all in our faces about how unreasonable our drug policy is. The Act is designed to protect safety. So it might well be that that risk of harm level is set where some cannabis products are acceptable and some are not. And that might be an issue that could be worked through, for example, by affecting the means of administration or the potency or some of the other ways of sort of minimising the harms that we've talked about throughout today. One of the other challenges coming forward for the Act is around premise regulation. There are two ways in which psychoactive substances can be, or products can be sold under the Act. The first is through a licensed premise, which is to say a physical location like a store, and the second is over the internet. Substances sold through a store are subject to a range of controls. The store can't be a dairy, that's essential. The store can't be a service station, it can't be a car, it can't be a tent, it can't be near somewhere that children congregate. For some reason, the mobile car thing is something that comes up in each and every attempt at regulating drugs in New Zealand. I don't know why. I don't know who it was who went around selling drugs out the back of a car, but clearly it had such an impact on our policymakers, they've never forgotten it and they just keep going on about it. So one of the challenges there, of course, is for communities, because communities do have some not unreasonable concerns about the prevalence and availability of psychoactive substances and where those stores will be located. The Act enables councils to set policies around where those stores will be positioned. Councils have currently adopted a range of policies, or are in the process of doing so, some of which are sensible and control density, and some of which are one step away from beheading all store owners in the town square. Probably the balance needs to be struck somewhere in the middle. I'm particularly entertained by Hawke's Bay, which has told Napier, where we're told at some length that the people of Napier don't want these substances sold in their communities, so their council's in the process of approving a local alcohol plan, a local approved products policy that will push them all out of the CBD and make sure that they set up shop in the suburbs, which is perhaps not what the good people of Napier were expecting. The other issue is around internet sale. Internet sale is, on some senses, has advantages because it avoids the amenity issues with the sale of substances from a store, but it has other risks, and the biggest risk is around verification of age. Keeping these substances out of the hands of under 18-year-olds was a key reason this Act was passed. It is an offence to sell to an under 18-year-old. The Ministry has been industriously picking on retailers over the last 3 months for selling to under 18-year-olds. They've managed to pick up more people for selling synthetic cannabis to under 18-year-olds in the last 3 months than they did in the last 2 years, even though it was illegal back then as well. So for store owners, that's fine. Check ID, make sure the person looks old enough, etc., etc. For online sale, it's a bit more challenging because you don't obviously have any way of verifying the ID of the person in question. And at the moment, the Act doesn't actually require you to have any particular system. It just says that if you get it wrong, you're in big trouble. That's something that's expected to be cleared up by regulations. One of the other things that's quite odd about the internet sale is that you're only allowed to sell your products from a website that is set up specifically for that purpose. So you're allowed to sell from a website that exists purely to sell drugs, but if you want to sell in the context of a wider business, technically under the Act, you're not actually allowed to do that, and it's not quite clear what the benefit of that is supposed to be. The controls on advertising, I think, are sensible. They are very broad, but they do keep these substances from the sort of big tobacco, big alcohol issues. And I was saying just before to someone that one of the things you do get the impression over when you look at the controls on approved products and the controls on retailers and the controls on advertising is that the officials basically sat down and said, what are all the things that we hate most about what alcohol does and about what tobacco does? Let's just put all those in there and make sure none of those ever start again. The only thing they haven't put in there, which I think is interesting, is plain packaging. And the reason for that was this came up at Select Committee. It was a suggestion whether or not the bill should be changed, that every psychoactive product had to be plain packaged. And it has a certain appeal to it because, after all, we're thinking about plain packaging tobacco. Doesn't it make sense to have consistency? And the view the Ministry took, I thought, was a quite interesting one. It reflects one of the real challenges in regulating psychoactive substances. The Ministry's advice was that tobacco is a pretty homogenous product, and it doesn't really matter if someone thinks they're buying one type of tobacco and gets a different one. But psychoactive substances are not homogenous. As we've just heard, they're not even homogenous across the cannabinoid category. So it's kind of important that people know what they're buying and that they can rely on a particular brand and know what they're getting. That might change in the future. But for the time being, the view remains that it's appropriate that psychoactive substances be packaged as necessary. The Expert Advisory Committee will be interesting. It hasn't been appointed yet, as far as I'm aware, but it's key because it will have a range of members with actual experience. To date, New Zealand drug policy has been made effectively by 120 elected MPs based on what they think people would like to hear. We have expert officials. Sometimes they give advice, sometimes it's taken, sometimes it sits unactioned for 3 years, both of which are currently in outstanding situations. The Act doesn't, as I said before, the Act is not specifically about synthetic cannabis. It covers a wide range of potential substances, but synthetic cannabis is the key one. Because obviously, as we know, it's the one that everyone's most interested in, it's the one that's causing the most concern, and it's also the one to which the most interim approvals have been granted. So in that sense, the Act, while it is called the Psychoactive Substances Act, most people would see it for the time being, I suspect, as the Synthetic Cannabis Act. One of the other issues about the Act going forward, and cannabis is one of only a number of potential products that could find themselves trapped by this, is it's not clear how the Act applies to substances that you grow or substances that you can grow at home. It's all well and good to talk about regulating synthetic cannabis through this Act because, as I said, you can regulate every stage of the market. You can control the manufacturer and the importer and the wholesaler and the retailer. But it's a bit more difficult when your manufacturer is some guy who's had a few seeds blown into his back garden, and the wholesaler is his friend down the pub, and the retailer might be some other guy. And because that's one of the areas I think would have to be changed if we're ever going to bring cannabis within the ambit of this Act, is a clear explanation of how it fits together with substances that you grow. But nevertheless, I do think in the long run, the future probably of cannabis law reform does lie in the Psychoactive Substances Act. It lies there for two reasons. The first is that it is an act that makes sense in terms of controlling cannabis. It sets the controls we would want to see on the sale and supply of cannabis. The second reason is a very simple one. It's a political one. It is going to be very difficult, I think, for any government to introduce a sale and supply of cannabis act. They would have to start from first principles and work all the way down. But if you've already got the Psychoactive Substances Act, it imposes those controls. You know that they work. You know they're what people want. So you could very easily, if you were so inclined to do so, put cannabis into or under this regime. It would remain controlled insofar as you could not sell or supply cannabis that was not an approved product, but it would create a vehicle for legal cannabis to enter the market. And for that reason, I do think the Psychoactive Substances Act is a key step forward. I think if you're interested in cannabis law reform, you need to read the Act very carefully, you need to understand how it works, and you need to pay very close attention to the developments in the Act over the next probably next 5 years. That's really all I've got, but if anyone's got any questions, I'd be happy to take them.
Actually, if we can have our other previous speaker up here as well, just quickly, and we'll just, we've probably got about 5 minutes just for some very quick questions. So.
I may have misheard you in relation to the packaging. I get the point that there may be different products, and therefore you may need to have information on those products. That's not an argument against regulating the nature of the packaging. And so, we do that with pharmaceuticals. I think there is a difference between saying, well, we need to make sure people have information so that they can make informed judgment. And that's about words. It's not about the colour of the package or the images that might be imposed on the package. And that seems to me an argument to have plain packaging legislation and probably as a regulation as opposed to a part of the Act so that it can be readily changed without having to bring the Act back to a full debate.
Yeah, look, I can see where you're going with that, and I do think that to some extent a lot of the concerns around synthetic cannabis in New Zealand came from how the products were being packaged and marketed. I mean, the authority basically rejected outright the first product that was put forward because its name was not repeatable in polite society. And there are obviously concerns that are reflected in the Act on the controls on how you can package and market a product that reflect, as you say, those issues around whether brand is really necessary. I think one of the other things, though, is that there is a distinction that I would make between tobacco products and approved products. And that distinction is that at the moment, there's not really a sense that approved product brands are perhaps used in the same way that tobacco brands are used. The concern is that basically the rationale, as I understand it, for introducing plain packaging is that it is a way of circumventing controls on advertising and marketing. That concern hasn't yet arisen with approved products. I'm not saying that it never will, but it's not something that when the Select Committee was considering the bill, they thought was big enough at the time to need to be addressed. As you say, I think if we do decide in the future that it's a problem, and I absolutely agree with you that it could well turn out to be a problem. The regulations made under the legislation should be robust enough to address that eventuality if it comes up. It would be a regulation, yes.
Any further questions over here? Can we get a...
Yeah, question for Steve. Just going back to the harms that you discussed as being identified by people using chronic and so on in Australia, were there any incidents of people who had previously not exhibited psychosis, reporting psychosis following their ingestion of the synthetic cannabinoids?
I don't actually have the data on that, on whether or not that was the case. Most of the case studies that have been published internationally indicate that there are people that have had some sort of predisposition or have had some previous psychotic episode, usually cannabis related, because most people using synthetic cannabis have previously tried cannabis. And I'm not aware of any cases where somebody has had a first time presentation, but one of the big problems with this is we don't have good data. So that may be the case that it is out there, but we don't have any data to indicate one way or the other.
Sir?
A question for Mr. Dunne. You mentioned the idea of ultimately having a framework that covers all substances, which makes sense from the point of view of consistency and fairness, I think. But I'm just wondering, when you've got a binary of approved with a certain set of rules and unapproved, is that going to be enough in the future? Like, do you see a possibility that ultimately you'd have a tier of low-level risk, slightly higher level risk? Do you see what I mean with different...
I do. I think the first way you would set about resolving that is by imposing different controls on approved substances at different levels of risk. But I think the other thing it's important to say, and it's something I should have covered earlier, so thank you for reminding me. One of the things I do think that the Act got wrong is that it criminalises the possession of unapproved substances. There's no reason to do that. There's no evidence whatsoever that there's some huge secret market in unapproved drugs out there. And yes, on the one hand, the police have the option to give you a $500 instant fine if they want to, and that's good. That's better than nothing. But to me, it's not necessary to have that particular level of criminalisation isn't necessary. It's clear that if you're going to impose control on unapproved substances, you should be penalising the people who manufacture and sell them, not the people who happen to use them.
Great, that's probably all we've got time for. Thank you very much. There was one thing I forgot to do.